I'm Marcus Thorne, and I've been practicing probate and estate litigation in Florida for 18 years, unraveling the most complex family disputes and challenging wills that just don't sit right. Sometimes, though, a case lands on your desk that makes you question everything you thought you knew about human nature, a story so wild it feels like fiction. This particular case started like many others, with grief and confusion, but quickly spiraled into a dramatic saga of betrayal and a hidden life so elaborate it stunned everyone involved. I still remember the day Sarah and Michael Thompson walked into my Palm Beach office. Their father, Arthur Thompson, a prominent real estate developer, had passed away suddenly from a heart attack, leaving behind an estate valued at nearly $15 million. They were devastated, still raw with grief but also utterly bewildered by a new will that had surfaced. This isn't just about money. I could see it in their eyes. It was about their father's memory, his legacy, and the sudden shattering realization that their entire understanding of their family might be a lie. The shocking detail, the one that made my stomach drop and told me this was going to be a battle, was the discovery that this new will, signed just 3 months before Arthur's death, completely disinherited them, leaving almost everything to a woman they had never heard of, a wife named Eleanor Vance, and her 2 children, ages 10 and 12. What was at stake wasn't just their inheritance, it was the truth, the very fabric of their family's past, and a fight to ensure that their father's true wishes, whatever they may have been, were honored. Here's what you need to understand about a will contest in Florida. Under Florida statutes, paragraph 732, 501, any person of sound mind who is 18 or more years of age may make a will. The key phrase there is sound mind. A will can be challenged on several grounds, but the most common are lack of testamentary capacity, undue influence, or fraud. Lack of testamentary capacity means the person didn't understand what they were signing, the nature and extent of their property, or the natural objects of their bounty, who their heirs typically would be. Undue influence occurs when someone, usually in a position of trust, substitutes their will for that of the testator, overcoming the testator's free agency. Fraud involves intentional misrepresentation to induce the testator to sign a will. In this case, Sarah and Michael suspected a combination, that their father, in his final months, had been manipulated, or perhaps even deceived, into signing a will that completely contradicted his decades-long estate plan. They believed this Eleanor Vance had taken advantage of him, and the law provides a path to challenge such actions, placing the burden on the proponent of the new will to prove its validity once a prima facie case of undue influence is established. This legal framework was our roadmap, a complex one, but one that offered a glimmer of hope to 2 heartbroken siblings. Sarah, 41, a meticulous architect, and Michael, 38, a driven financial analyst, were Arthur's only children from his marriage to their mother, Margaret. Arthur and Margaret had divorced amicably years ago, but Arthur had always maintained a close relationship with his children. He was a demanding but loving father, a pillar of the Palm Beach community. For decades, his will, meticulously drafted and updated several times over the years, clearly divided his substantial estate between Sarah and Michael. They knew it, their family attorney knew it, and, frankly, so did half the town. Arthur was known for his sharp mind and unwavering business acumen right up until his final year. That's why this new will, dated December 15, 2021, and filed for probate on April 1, 2022, felt like a slap in the face. It named Eleanor Vance, an unknown woman, as his beloved wife and primary beneficiary, along with her 2 children, and reduced Sarah and Michael's share to a mere 10% combined. When they sat across from me that May afternoon, their faces were etched with a profound sense of betrayal. Sarah clutched a crumpled tissue, her voice trembling as she recounted their shock. Michael, usually composed, kept running a hand through his hair, his eyes darting around my office as if seeking answers on the walls. They explained that their father had seemed a little more forgetful, a bit more withdrawn in the last year, but nothing that suggested he was mentally incapacitated. He had always been so private about his personal life, but this? A secret family? It was unfathomable. They had confronted the attorney who drafted the new will, a Mr. Richard Hayes, who simply stated Arthur was of sound mind and knew exactly what he was doing. They showed me old photographs of family vacations, beaming smiles, a lifetime of memories, and then the stark contrast of the cold legal document. I looked at their raw grief, their confusion, their desperate need for answers, and I knew this wasn't just a job for me. This was about restoring dignity and fighting for justice against what felt like a truly egregious wrong. My investigation began immediately, a deep dive into Arthur Thompson's last year. The first order of business was to issue subpoenas for Arthur's medical records, bank statements, phone records, and any emails from the relevant period. I also engaged a formidable team of experts. I hired Thomas T.J. Jenkins, a private investigator known for his uncanny ability to unearth hidden lives. His mission: find out everything about Eleanor Vance, her background, her relationship with Arthur, and whether Arthur had truly been living a double life. For the financial aspect, I brought in Rebecca Green, a forensic accountant with a razor-sharp mind for tracing money trails. Her task was to scrutinize every transaction in Arthur's accounts for any anomalies. Finally, anticipating a challenge to Arthur's mental state, I consulted Dr. Evelyn Reed, a forensic neuropsychologist, to review medical records and any available personal communications for signs of cognitive decline or susceptibility to undue influence. The initial weeks were a grind. Mr. Sterling, the opposing counsel representing Eleanor Vance, a well-known, aggressive litigator with a reputation for playing hardball, immediately stonewalled our requests, asserting attorney-client privilege and privacy rights. We had to file motions to compel just to get basic information. Sarah and Michael's friends and business associates, while saddened by Arthur's passing, had no idea about Eleanor. It was like she materialized out of thin air. TJ, however, started to get some traction. He tracked down property records in Vero Beach, a coastal town an hour and a half north of Palm Beach, showing a house purchased by Arthur 5 years prior in a trust where Eleanor Vance was the sole beneficiary. Then came the phone records, showing daily calls between Arthur's cell phone and an unfamiliar number, starting over a decade ago and intensifying in the last 18 months of his life. The true detective work began when Rebecca Green started sifting through Arthur's complex financial records. She found a consistent pattern of large, regular cash withdrawals, often $5,000 to $10,000, from various ATMs, far more than Arthur's usual spending habits suggested. More disturbingly, she uncovered a series of significant wire transfers totaling over $2 million in the last 3 years of his life, from Arthur's personal investment accounts to several accounts in Eleanor Vance's name. These transfers dramatically escalated in the 6 months leading up to his death. This wasn't just a new relationship. This was a complete financial entanglement, almost a parallel economy. Then came the emails. Among Arthur's personal correspondence, Dr. Reed found several emails sent in the months before the new will was signed that raised serious red flags. In one email to a business partner, Arthur mentioned a meeting they had just had, then asked, "Did we discuss this already? My memory isn't what it used to be." In another, he seemed to confuse current events with things that happened years ago. These weren't isolated incidents. They formed a mosaic of increasing confusion and forgetfulness, suggesting a significant decline in his cognitive abilities. This evidence, combined with TJ's findings of Arthur's double life in Vero Beach, made my strategic thinking crystal clear. We weren't just fighting undue influence. We were building a case for lack of testamentary capacity and outright fraud. The breakthrough moment hit me like a jolt of electricity one Tuesday afternoon. TJ called, his voice barely containing his excitement. "Marcus, I've got it. I found a marriage certificate for Arthur Thompson and Eleanor Vance." My heart raced as he sent over the scanned document. It was dated 15 years prior, registered in a small county in the panhandle of Florida. For a split second, a wave of dread washed over me. What if Arthur had divorced Margaret without anyone knowing? But then TJ delivered the actual smoking gun. "Here's the thing, Marcus. I pulled Arthur's divorce records. He never divorced Margaret. Ever. The records show his marriage to Margaret was still active when he married Eleanor Vance." I stared at the screen, the void marriage certificate glaring back at me. This wasn't just a secret family. This was bigamy. Eleanor Vance had married Arthur knowing he was still legally bound to Margaret, Or, at the very least, she had allowed him to believe it was a legitimate marriage, maintaining a fraudulent relationship for 15 years. This was the dramatic reveal, the piece of evidence that changed everything. The marriage was legally void from the start. TJ also sent me copies of the birth certificates for the two children, listing Arthur Thompson as their father. When I showed this to Sarah and Michael, they were speechless. Sarah's face drained of color, then tears streamed down her cheeks. Tears of betrayal, but also, I sensed, a profound shift. Michael slammed his fist on my desk, a raw, guttural cry escaping him. Their father had lived a double life for over a decade and a half, building an entire family on a foundation of deception. This wasn't just a new will, it was a testament to the systematic fraud perpetrated against their father, who, in his declining state, might have been manipulated into believing his second family was his only family. This evidence was legally significant because it established a clear motive for Eleanor Vance to exert undue influence and directly supported our claim of fraud in the inducement. She had presented herself as his wife, entitled to his estate, when in fact she had no legal standing whatsoever. The courtroom on the day of the trial was a solemn, hushed space, the air thick with tension. Judge Elena Reynolds, known for her sharp intellect and no-nonsense demeanor, presided. Sarah and Michael sat beside me, their postures stiff, eyes fixed on Eleanor Vance, who sat across the aisle with her counsel, Mr. Sterling. My key witness was Dr. Evelyn Reed, the neuropsychologist. She took the stand, her voice calm and authoritative as she explained her findings. She detailed how Arthur's medical records, combined with the emails I'd provided, painted a clear picture of a man experiencing significant cognitive decline in his final year. Based on the pattern of memory lapses, confusion, and difficulty with complex decision-making evident in his communications and medical history, she testified, Mr. Thompson's capacity to fully comprehend the implications of a radical change to his estate plan, specifically regarding the disinheritance of his long-established children, would have been severely compromised. Mr. Sterling's cross-examination was predictably aggressive. He tried to discredit Dr. Reed, pointing out, "Doctor, you never personally examined Mr. Thompson, isn't that correct? So your opinions are merely speculative, based on second-hand information?" Dr. Reed, unperturbed, calmly responded, "My analysis is based on comprehensive review of objective evidence, medical records, clinical notes from his treating physicians, and his personal communications, which are standard practice in retrospective capacity assessments. The pattern is consistent with early-stage dementia, a condition that severely impacts judgment and susceptibility to influence." He pressed on, suggesting, "Many elderly individuals experience forgetfulness. Are you suggesting every senior moment indicates a lack of testamentary capacity?" "Doctor," Reed countered, "no, but a consistent pattern of profound disorientation and confusion, particularly regarding personal relationships and significant financial decisions, is highly indicative of impaired capacity." Then came the moment I had waited for. I called Eleanor Vance to the stand. She was a poised, attractive woman in her late 50s, projecting an image of quiet dignity. I started gently, establishing her relationship with Arthur, the life they built together in Vero Beach. She spoke softly about their shared dinners, their private jokes, their children. Then I shifted. "Ms. Vance, you stated under oath that you were Arthur Thompson's beloved wife. When did you and Arthur Thompson legally marry?" She responded, "On June 10th, 2007, in Tallahassee, sir." I paused, letting her words hang in the air. "And Ms. Vance, when you entered into this marriage, were you aware that Arthur Thompson was still legally married to Margaret Thompson, the mother of Sarah, and Michael Thompson, whom he married in 1975? Mr. Sterling immediately leaped up. "Objection, Your Honor. Irrelevant. This is a probate case, not a divorce proceeding or a bigamy trial." Judge Reynolds held up a hand. "Mr. Sterling, this court will allow the question. It goes to the very heart of the claimant's asserted relationship with the testator and may be relevant to the issue of fraud and undue influence. Answer the question, Ms. Vance." Eleanor Vance hesitated, her composure visibly cracking. Her face began to drain of color. That's preposterous. Arthur told me he was divorced years ago. He showed me papers." I leaned into the microphone. Miss Vance, are you stating that Arthur Thompson deceived you? Because we have documented proof that Arthur Thompson was never divorced from Margaret Thompson, and therefore your marriage to him was legally void from its inception. I presented the original marriage certificate of Arthur and Margaret Thompson, along with official Florida Circuit Court records confirming no divorce decree had ever been filed or granted. The courtroom went utterly silent. Eleanor Vance visibly crumpled, her shoulders slumping. Her attorney, Mr. Sterling, stared at the documents, then at his client, his usually confident posture suddenly defeated. His jaw was tight. I then presented the void marriage certificate from Tallahassee, effectively proving she had either known about the bigamy or been incredibly negligent, and the birth certificates of her children, showing Arthur as the father. Ms. Vance, for 15 years, you lived a life with Arthur Thompson, knowing or having every reason to know his true marital status. And now you present a will where he leaves you and your children the majority of his estate, disinheriting his legal children, a will signed when his cognitive functions were clearly declining. Was this not a calculated effort to benefit from a relationship founded on deception? Eleanor Vance couldn't even meet my gaze. She just shook her head, tears silently streaming down her face, uttering a faint, "I loved him." Her love had blinded her to the legal and ethical boundaries, and now it was all laid bare. The judge's expression was stern, her pen poised over her notes. The judge's ruling came swiftly and decisively. After considering all the evidence, Judge Reynolds declared the December 15, 2021, will invalid on grounds of both undue influence and fraud. She cited the overwhelming evidence of Arthur Thompson's diminished capacity, the clear pattern of deception by Eleanor Vance regarding her marital status, and the drastic and unexplained deviation from Arthur's decades-long estate plan. The previous will, dated 2010, which left the entirety of Arthur's approximately $15 million estate to Sarah and Michael, was reinstated. The outcome for Eleanor Vance was stark. She received nothing from Arthur's estate. The court did not pursue criminal charges for bigamy in the civil case, but her reputation and the life she had built on a lie were irrevocably shattered. For Sarah and Michael, the victory was bittersweet. There was immense relief and gratitude, a sense of justice served. Sarah wept openly, burying her face in Michael's shoulder, who held her tight, his own eyes wet. They had fought for their father's true wishes, and they had won. Weeks later, in a testament to their own character, Sarah and Michael, after much private discussion, established an educational trust fund for their two half-siblings. It was their way of acknowledging the innocent children caught in the crossfire of their father's secret life, a gesture that spoke volumes about their integrity. This case taught me a profound lesson about the depths of human deception, but also the incredible resilience of family bonds and the power of truth. It reinforced my belief that while money is often at the heart of these disputes, it's usually tangled up with far more complex emotions: betrayal, grief, and the desperate need for validation. The broader legal lesson for anyone watching is simple. Do not make assumptions about legal relationships, especially when significant assets are involved. There are warning signs everyone should watch for when an elderly or vulnerable loved one is involved. Sudden, unexplained changes to a will or estate plan. New friends or partners who isolate the person from their original family. Secretive financial dealings, and any marked decline in cognitive function. My practical advice is this: get your estate plan in order early in life and review it regularly with an experienced attorney. Discuss your wishes openly with your family. If you suspect undue influence or exploitation, don't wait. Consult with a probate litigation attorney immediately. The quicker you act, the better your chances of uncovering the truth and preventing irreparable harm. This case was a stark reminder that beneath the veneer of respectability, human nature can be incredibly desperate and complex, driven by motives both noble and nefarious. Months later, Sarah and Michael are thriving. They've honored their father's legacy by investing wisely and giving back to the community he loved. They've even tentatively begun to build a relationship with their younger half-siblings, navigating the complex emotions with grace and maturity. It's stories like these, the raw, unfiltered human dramas, that remind me why I do this job. To untangle the lies, to fight for justice, and to help people find their way back to solid ground when their world has been upended. Drop your questions in the comments below, and I'll do my best to answer them. Like this video and subscribe for more real-life legal sagas. I've got plenty more stories to tell, and next time, I'll share a tale of corporate espionage that reads like a spy novel.